The former public protector, Advocate Busisiwe Mkhwebane's legal action over a multi-million rand gratuity kicked off with immediate challenges which need to be resolved prior to the hearing. This as the respondents in the matter argued that it should not be entertained by the urgent court role, highlighting a lack of compliance, urgency, and why a special allocation is appropriate. The Office of the Public Protector submitted that on various reasons, the matter was improperly enrolled.
This is not a special allocation. This is a normal urgent motion role. So for those three reasons, the case is in fact not properly enrolled, not by us, but by the applicant. There is obviously the fourth overriding issue, that the case is not urgent. It's improperly enrolled as an urgent application in the urgent court when it is not urgent.
Counsel on behalf of the fifth respondent, the Speaker of the National Assembly, echoed similar sentiments.
Having regard to the contents of paragraph 50 of the founding affidavit, where the question of a special allocation is raised, and we'll give your ladyship reference to authorities on why it is inappropriate for a complex issue with novel principles, from an appropriateness perspective, why it is not appropriate to be argued in the urgent court, and because that impacts on the question of urgency. That's why I was saying, my lady, without getting into the merits, we've got the chronology argument on urgency and the appropriateness argument with reference to authorities and why a special allocation is appropriate.
Counsel on behalf of Mkhwebane submitted that there was no undertaking with the parties that they would request a special allocation.
This is what we said at paragraph 50, my lord. We said the matter is set down on the urgent basis and so on and so on. Then we say, be that as it may, and in spite of its urgency, I'm advised to have agreed that the attorneys of any opposing respondents, if any, be approached, right, with a view to writing a joint letter to the Honorable Deputy Judge President requesting a special allocation of formula due to its nature and public importance, to an expedited date agreed by the parties. Failing such agreement, which is where we are, there's no such agreement, the matter will be enrolled on the ordinary urgent roll on a date identified by the applicant in the notice of motion. That date is the 16th of April, which is today.
The Gauteng High Court in Pretoria stood the matter down until Thursday, with parties expected to have at that stage clearly defined the issues the court must determine. Kani Maphanga, SABC News, Johannesburg.